The following is paid advertisement does not reflect the opinions of this station. The choice of a lawyer is an important decision and should not be based solely on advertisements. The information presented in this program is general and is not intended to be legal advice and should not be relied upon or used without consulting a lawyer to consider your specific circumstances.
Questions about law, stories from the courtroom, cases that might impact your life. It's time for Tell Me I Have a Case with Dan Grimm and Matt Glenn from Cook, Barquette, Ponder, and Wolves. Find them at cbpw-law.com. Here's Dan Grimm and Matt Glenn.
And good morning and welcome back to Tell Me I Have a Case, the show where we invite you to take a second look at the world of personal injury law. I'm Matt Glenn alongside my partner Dan Grimm. We're from Cook, Barquette, Ponder, and Wolves. You can find us on the web at www.cbpw-law.com or at 573-335-6651. Today we're going to be talking about the importance of gathering evidence early in your case. And we're going to talk about that initially in the context of a premises case. Now, a premises case is a case where someone is injured as a result of a defect in the defendant's property. Usually you're talking about a fall in a store or in a parking lot.
And Matt, I think you recently had a case that kind of highlights this point perfectly.
Yeah, I did. I had one that we actually tried back in September.
Fantastic result for the client.
I appreciate that. Yeah, we did, and thank you for your help in that one. Essentially, my client was at the defendant's location. He had his 5-month-old granddaughter in his arms, and there was a rocking chair there for him to sit in. He sat down in the rocking chair. He leaned back, and the chair snapped in two, and he fell backwards. And kind of in an effort to protect his granddaughter, which he did, thankfully, he felt a pop in his lower back.
And in that case particular, what was important as far as evidence gathering that you need to do early in the case rather than later?
Well, the most important thing that my client did was report the injury to the defendant. He told him, hey, I've fallen backwards, this chair broke, and I am hurting. The big question in any premises case is, was there a defect on the defendant's property that the defendant knew or could have known about? And in this case, it was the chair. Was the chair defective, and could the defendant have known about that chair? By telling the defendant that he was injured, the defendant then had a legal responsibility to maintain the evidence that's under their control. They own this chair. They're the ones who own the chair, and they chose to actually throw it away within 72 hours after this incident occurred. It's hard to prove that a chair is defective when you don't have the chair. But because the defendant was the one that threw it away, and because my client had told them he was hurt, we had at trial, we were able to have a presumption that if that chair had been available, it would have shown some negative evidence for the defendant. That was very helpful in getting that result.
Wow. So if somebody has a premises liability case, what steps should they take to help preserve evidence, if you will?
Yeah, like I said, the most important thing is you notify somebody about the fall. If you're at a big box store or at a grocery store, oftentimes there are cameras that show the fall, that show everything that's going on in that store. You want to make sure that you notify the defendant the minute that you're hurt. Right? The instant you slip, if you slip on a puddle or you step on a grape in a grocery aisle, or you hit a floor mat that has a wrinkle in it and you go down, you need to tell somebody. Even if you feel like your injury is minor at that point, because we've talked about it before, you may wake up in a day or two and realize, my gosh, my knee's not getting any better. I've got some serious issues here. If you tell the defendant, you tell the owner of the store, the manager, an employee, that triggers their responsibility to then begin saving that evidence. And that's key, because those cameras, they'll record over themselves after 2 or 3 days, and then you're stuck without that evidence.
And what type of evidence have you seen over your years of practice that's key to helping prove up your case?
The videotape is oftentimes our strongest tool in getting a recovery for our client. I had a case against a large chain where they had a water refill station. And at that water refill station, customers would actually fill their water bottles up and then go up to the front and pay for them. Because customers were working with water and water bottles, oftentimes there were spills in this area. And so the manager had a policy that anytime one of his employees walked by that area, they wanted them to look at that specific spot to see if there was a puddle there. They'd had a lot of puddles in the past, and they really wanted them paying attention to that. Well, because I had the videotape, because my client reported the fall, I was able to show that 18 employees walked by that area during the 25 minutes prior to the fall, and not one of them took one glance over at that area. Not one of them. And had they looked over there, they would have seen a puddle, and they would have gone over there, and they would have cleaned it up, and my client would not have fallen.
So, other evidence as far as any statements or witnesses?
Sure. You're always going to be talking to the employees that are there, the manager, but you want to get down information about another customer that might have seen you fall. These are people oftentimes you don't know. You've never seen them before. You're never going to see them again. Get as much information about those people as you can, to the extent that you can. If you're in pain and you're on the ground, focus on yourself. But if you've got somebody with you, maybe a spouse or a child who's old enough to help you out, you want to go ahead and try to get the information from the witnesses if you can. Try to get them to write it down, or get the employees to write down the witnesses' information. It's hard to find these people a year or two down the road, but it's pretty easy to find them, a few months down the road.
And going back to your case that you last tried, what other type of evidence did you in your investigation did you come up with to help prove your case up?
Well, it was the statements that my client made, to the defendant. It was the observations of the defendants themselves when they walked in and looked at the case. It was their initial evaluation of the claim, where they believed early on that they were responsible for the claim. That's why they wound up throwing it away. And all of that really combined with that presumption to make it a pretty strong premises case. Premises cases are always defensible. The defendant will always argue that you should have seen the puddle that you slipped in, or that you should have noticed the loop in the floor mat. What we always point out to people, and what's important to bear in mind as you're shopping, the defendants, the store owners, they don't want you looking at the floor. They want you looking at the merchandise on the shelves, because that's what you can buy. We often joke, there are a lot of things for sale in a grocery store, but one of the things that's not for sale is the floor. Right? They don't want you walking around staring at the floor, because if you do that, you're going to get to the end of the store aisle, and you will have avoided every puddle, but you will also not have anything in your shopping cart, and that's not why you're there.
In this early investigation, is this something that clients can do on their own, or is it something that really works best with attorneys or people that kind of know what to look for, when to look for it, and how to look for it?
It's vital that you get a lawyer involved early in these cases. Premises liability law can be counterintuitive. And this is true on the defense side, and it's true on the plaintiff side. I'm always telling my clients, the minute the fall happens, just document everything. You want to measure how big the puddle is. You want to take a look at it. What did I slip on? What caused me to lose my balance and go down? And you want to look over and see what it was. If it's a puddle of water, take note of how big it is. How big it is how big it is, right? If it's a huge puddle, the defendant's going to argue you should have seen it before you slipped in it. If it's a tiny puddle, they're going to argue, well, it's not big enough to have caused you to fall. The puddle is what it is. Just document it and give us the information. I'm forever telling my clients that it's never your job to make a fact look good or bad in a case. That's what you pay us for. That's our job. We make the facts look good. We make the best case for you under the law. You know what happened, and you know how to document what happened, but we're the ones who are the experts on the law. So get us all the facts as best you can. Document them as best you can. If you have somebody with you, get some photographs, get some statements, some information on some witnesses, and then let us do our job.
And like the photographs, I think is very important too, because the scene's going to change. Their protocol is going to be, if there's a puddle on the floor, they're going to come out and mop it up. And there's always a dispute over how big the puddle was or how small the puddle was, what was the color of the puddle, what type of liquid. And the photographs or video just really help corroborate what you're saying, because obviously that evidence is going to be mopped up and disappear.
Right, and that's another reason why it's so important to get that videotape afterward. These companies they're required to save it if you report that you fell to them. They are required to hang on to that videotape, and if they don't, I've seen many cases like the one that I had, where the company will say, well, we accidentally erased the videotape. Well, then guess what? I get to say to the jury, if we had that videotape, it would show evidence that is beneficial to our side and not theirs. But again, you need an attorney to assert those legal principles for you.
And that's the same in trip and falls. Trip and falls, you want to take pictures of what you tripped over, how if it was a curb, the size of the curb, was it painted, was it not painted, did they have exciter killers on it, if it's something that was some type of merchandise that was in the hallway. Same thing, because all those things can be removed and changed, and then later on when we're trying to explain what happened, if it's not there, not documented, it's very tough to corroborate what happened.
Right, and very, very few of our clients understand the intricacies of the law when it comes to something like a curb. There are all sorts of regulations and codes as to how high the curb can be, whether or not it needs to be painted a different color, its positioning in terms of distance from the door. Does there need to be a ramp? Should there be anti-slip mats on that ramp? And that's why it's so important just to document it all. If you document everything and you get that information in front of us, then we can go out to the scene soon after the fall. We can take a look around, see if there's anything you missed. And then we can evaluate, hey, is there a code violation here? We can put your case in front of an expert who will look at it and say, my gosh, that curb, that violates the local building code, and that building code is there to protect you. That building code is there to protect everybody, the entire community, and to keep all of us safe. And if that code's been violated, then they need to take responsibility for that violation.
And as an investigation, do you find this early investigation is important in other types of cases?
Yeah, it's vital. I mean, just in general, we get a lot of cases that it can involve vegetation that are premises cases. That there may be a bush that covers up something that you wind up encountering because that vegetation is there. Well, the vegetation changes from day to day, and you need to be able to get out there early and get photographs of it. Maybe take measurements so that you can see what it is you're up against. We have a case right now that's a premises case involving actually a car accident, where a car was pulling out onto a main street down in Sykeston, and there was actually the snowplow company for this business had created this massive pile of snow that they put right on the corner. So you pull up to a stop sign, and there is absolutely no way for you to see oncoming traffic that's going by at 45 miles an hour unless you pull out into the lane. Well, that's a hazard that was created by that snowplow company. And every single day after that accident, that hazard was melting. It was going away. Getting out there, getting photographs of that scene in the aftermath of that accident was absolutely vital to the resolution of that case. Okay.
So you see that with auto cases, truck cases, train cases, and probably product liability cases, that early investigation is key.
It's always key. The earlier, the better. Like we always say, it doesn't cost anything just to talk to us. We can oftentimes guide you early on in a claim, and maybe the case never develops into anything that we take. But if it's going to develop into something, the sooner we get it, the better off we are. We'll talk more in the second segment about early evidence gathering in auto cases, train cases, product liability cases. You're listening to Tell Me I Have a Case, the show where we invite you to take a second look at the world of personal injury. For Dan Grimm, I'm Matt Glenn. Join us in a few moments.